Good afternoon, everybody. Thank you. Please be seated. Please call the case.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled In Re Cote, Maquam Shore Market, case number 24 AP 161. Representing the appellant, Janet Cote, is attorney Alexander LaRosa. Seated at counsel table with attorney LaRosa is Janet Cote. Representing the appellee, the Agency of Natural Resources, is attorney Melanie Keene.
Thanks very much. Good afternoon, counsel. We'll hear from counsel for the appellant first, of course. Please come on up to the podium if you would. And before you start, for the record, introduce yourself, identify your client.
Thank you, Your Honors. My name is Alexander LaRosa, and I'm with the firm of MSK Attorneys. I represent the appellant in this matter, Janet Cote, and Maquam Shore Market.
Thank you very much. Please go ahead.
Good afternoon. The appeal you have in front of you concerns the environmental court's decision of a denial, upholding a denial of reimbursement requests from Vermont's Petroleum Cleanup Fund. The Petroleum Cleanup Fund is designed to effectively be an insurance policy to help property owners remediate soil contamination within their property. The statute states that the secretary may authorize distributions from the Petroleum Cleanup Fund at varying limits depending on the nature of the cleanup.
Perhaps you're headed here, but let me ask.
By all means.
This is, as I read 1941, discretionary with the A&R as to whether or not they're going to make it. And if I'm right about that, then my question is, how does this decision show us how that discretion was exercised?
That is exactly the core problem of the appeal. The decision does not articulate a reasonable basis to understand how or why that discretion should be applied, and the record does not support any conclusion accordingly. The testimony in the record by the agency's witness, focusing on the two areas in this case, which primarily are engineering costs, the testimony in the record from the agency's witness is we generally don't reimburse those costs. Generally is not an appropriate standard for agency discretion. Generally, I generally have eggs for breakfast. Today I didn't. Why? We didn't have any. You know, what are the actual standards applied for generally? It's not in the record, and the court does not articulate a basis in its decision to guide what that discretion is or how it was applied or how it would be applied in the next case.
Isn't there that same problem, or at least a related one, with respect to the testimony that I believe was recited in the trial decision, that they'd never seen, the person testified, never seen a case where that was allowed, the reimbursement was allowed? How was that?
Well, that's exactly right. That is not a standard. Many people thought the world was flat and were convinced accordingly, but there is a first time. Ms. Cote asked, and the answer was, well, no one's asked before, so we don't reimburse it. But that's not an appropriate standard. I will also note that in this vein, the PCF procedures, which the court relied on, provide no other articulate basis. The general crux in the PCF procedures is that costs must be pre-approved and must be reasonable. Reasonable is a totally unfettered discretion.
Can I ask a question about those?
Oh, go ahead.
Can I ask a question about those rules? I'm really confused about something, and maybe you can help me. The agency witness testified on some matters that they were capital improvements, so they weren't covered. And then the court relied on that and said they're capital improvements, so they're not covered. But under the rules, it has what we cover and what we don't cover, and capital improvements is in the list of what we cover.
Justice Carroll, you are correct about that. The PCF procedures do say capital improvements may be covered that are pre-approved. But then you come to the question of when is something supposed to be pre-approved? The $85,000 in engineering costs, Ms. Cote learned she had to incur those to bring the site back to usability, asked the agency to reimburse them. before they were incurred, she asked for pre-approval. And so, in our view, she did the very thing the procedures would ask for pre-approval. And so if they are a capital cost, they would seem recoverable. The only reference for what's reasonable or not reasonable in the PCFs.
Mr. La Rosa, wasn't she denied repeatedly the approval request for the engineers?
I think there are multiple engineer requests, and I think the last time she followed the administrative remedies, as I understand them, she was asked to have them reimbursed. There was back and forth discussion about that. Ultimately, that went up to the secretary, and there was a letter which was then brought on appeal to the environmental court. So there may have been ongoing discussions about that, Justice Waples. But I think ultimately she sought pre-approval before they were fundamentally incurred.
And on that same point, when you're talking about the engineering, is that what was referred to as the general contractor?
Yes, that's right. It's about $85,000 to ascertain the boundary of the property, to finally obtain a CO from the city of St. Albans for the full remediation and repair and restoration.
There was something to do with compaction studies that
The compaction studies.
entirely certain about what the general contractor was going to do in toto. I didn't see that set forth anywhere.
I don't believe the decision sets forth of that, and I don't have a complete recitation for you now, specifically the scope of the general contractor studies. I do understand that the testimony in the record from the engineering ventures witness was that it was a comprehensive analysis necessary to obtain a CO and obtain final approval for the rebuilding of the property, which ultimately was incurred as a result of kicking off the soil remediation process.
And on that point, didn't the trial court, I'm sorry.
No.
On that point, didn't the trial court say it wasn't necessarily covered? And it kind of left the whole necessarily hanging there.
Yeah, I think that's part of the issue of the trial court is that if you, as I read its decision, the sort of central analysis it provides on this issue is on pages, at page 11 and pages 10 to 11, bottom of 10, the top of 11. And it really doesn't provide any analysis for why, for example, it's overturning some costs for wastewater engineers and wastewater restoration, but not, which I think are as capital as anything else, but not these other engineering costs.
Would you agree that the standard of review for the findings would be clear error?
May I look at my brief, Your Honor?
You may.
Justice, sorry.
Well, let's just assume that's clear error.
I would defer to you on that point.
So, and where does this rise to the level of that standard?
I believe it rises to the level of that standard to the extent that the court fails to fundamentally set forth a requirement that this court has said, which is a trial court's decision on these matters must have as a reasonable basis, testimony to support it, must make factual findings clearly articulating it, and must identify how it reached its conclusion. And I think the cases cited in the brief, New England Power, particular, identify that's error of the court if it does not include that in its decision. May I say it colloquially in the sense of I read the decision as a practitioner and I can't advise a client in the next similar case why or how costs are covered or not covered, which seems to me the fundamental job of the trial court in interpreting an issue like this.
On the punch list, should or should not have the court gone through every single one of those items on the punch list?
I believe it was required to as well. I think because if we're breaking down what's capital and what's reasonable, the procedures would require you to identify, well, this cost is yes and this cost is no, and this and why, and it doesn't do that. But with that, I'd like to reserve unless there's no more questions, I'd like to reserve the rest of my time for rebuttal.
So one quick question. The original letter from the agency was in the year 2000, which found that there was contamination from an underground storage tank. And there was an agreement, including the use of monitoring. And then nothing occurred until the incident when the tractor hit the house in 2012. And at that point, it became apparent that there was more contamination. I just want to see if there's anything, say what happened in those 12 years where it wasn't flagged that the pollution was occurring on land.
I don't know the answer to that.
Okay, thank you. I couldn't find it and I'm not sure it's relevant to anything, but
I don't know the answer to that question. It's certainly a good one, but I don't know the answer.
Thanks.
Reserve the rest of my time. Thank you very much.
All right, thank you. We'll hear from counsel for the appellee, please. Introduce yourself and identify your client for the record.
Thank you, Your Honors. Melanie Keene for the Vermont Agency of Natural Resources. The decision on appeal is well-reasoned if you look at the context of the statute, and it's well supported by its findings. The legislature established the PCF to help uninsured Vermonters pay for the cleanup and remediation of petroleum contamination from underground storage tanks. Section 1941B gives the secretary broad discretion to authorize PCF payments, but the legislature intended the PCF to cover reasonable costs of cleanup and restoration of contaminated soil to protect public health and the environment. While the legislature did grant broad authority, the PCF is not a blank check. Reimbursement claims are reviewed and approved in advance to ensure that cleanup and remediation costs are reasonable. Pre-approval is an important requirement in the procedures for PCF reimbursement. It helps ensure that funds are available for other sites. The $1.24 million statutory cap in the law is not an entitlement, and it does not indicate legislative intent to require reimbursement of costs that are not related to cleanup and restoration of contaminated soil.
Can I ask a question? I was just going to refer to that, the purposes of cleanup and restoration. At one point, the agency agreed to replace a basement, and I think did replace the basement. And so I'm wondering how that falls under cleanup and restoration from the DAS.
Thank you, Your Honor. This is a very broad discretionary statute. And what happened here was you have a store rebuild ongoing where the contamination was discovered. In restoring the site rather than restoring the slab, she wanted the basement. In the context of the whole amount of site work, secretary exercised that discretion, approved that as a reasonable cost. Under those facts and circumstances of that particular case, it was authorized.
So then that follows that the individual who testified for the agency was relying on something had never been done before, so we're not going to do it, which is pay for the engineer. To his
see.
knowledge, they never had paid for one of those, but yet then on the other hand, you're arguing that maybe the basement shouldn't have been paid for, but the agency used its discretion. I mean, when can
Okay.
they and when don't they?
We are not arguing that the agency didn't have discretion to authorize the basement or that it had never happened before. And I think it's important to bear in mind this was a de novo trial and that the court's decision does not rely on any findings that it cites testimony that certain things had not happened before. But at its core, this decision seems to be that appellant put on no evidence that additional work was needed. Any additional costs were needed for cleanup at that site, number one. And then number two, the total of over $485,000 accrued to that point was cited in the court's decision as being significantly more than had been spent on similar sites of similar scope, size, complexity around the state. So bearing that in mind, the court, standing in the shoes of the agency, exercised that discretion, again, through the lens of 1941B, the purposes of cleanup and keeping funds for other sites, and held that those costs should be denied.
And if it's a discretionary thing with the A&R, don't we have to know how that discretion was exercised? Simply saying that, I guess I'm not going to authorize payment for that, doesn't tell us the thought process that goes into it. And I'm having a hard time seeing that in the decision.
Are you? I believe, Your Honor, the decision as a whole, perhaps it could have been more clearly written, but the bases are there, we argue, under 1941V. This is not like the MVP case where the Green Mountain Care Board denied a rate increase and there were statutory elements that were in part addressed in their decision, but then they also added some things about lateness of the filings and mistakes in the filings that weren't relevant to the statutory scheme. This court remanded there for additional findings on why those things mattered because it wasn't clear from the decision. Here, I think the decision from Judge Durkin did not rely on extraneous factors. It relied on the key tenets of the statute, which are cleanup and restoration of contaminated soils, of which there were none left at this site.
The cleanup was already done by 2015, correct? And this punch list was then submitted well after that.
Correct. The agency worked with appellant for a long time after the cleanup was complete to go over what buttoning up remained on the site. Remember, she had a store rebuild project in progress. So for instance, the final seeding, grading and planting mulching was on hold pending completion of those sorts of things. So there was a final punch list. The agency did approve several of those items in that punch list. Additional soil compaction testing, sealing the wastewater system covers, final grading, seeding and mulching, those were approved. They're not at issue here. But the additional punch list items she required, the court below found were not for cleanup, many of which were due to contractor issues. Under section 66-115, it is the owner of the property who is responsible for the cleanup and for dealing with any contractor issues. Contractors have insurance for that sort of thing. That is not for the PCF to reimburse.
What does the word incur mean in this context?
Thank you, Your Honor. I think appellant correctly defines the word incur, but it is that context that really matters here. Incurred by corrective action on the site is in the statute at 1941B1 as part of a list within a category. And that category is the cleanup and restoration of contaminated soil in 1941B. And then you have including corrective action for the cleanup and restoration of contaminated soil. These expenses do not fall within that category. Could the court or the secretary at the time of cleanup authorize some of those costs to get the site completed and closed? Perhaps. It's not error to do what is best for the state and get a site buttoned up and save that money in the fund for the next problem.
And there's a preservation issue. Is that right, Ms. Keene?
Yes, we argue that the argument about the definition, lack of a definition of capital improvement was not briefed below. It wasn't. But we don't think that the definition of capital improvement really is at issue here, because these costs, as the court has pointed out, were never pre-approved during the cleanup and restoration of the site. They were not in that context considered reasonable costs by the secretary or the court on appeal. And in that way, it's important to note the court's decision was not internally inconsistent when it reversed the agency on the concrete and electrical costs. Those had been denied below at the administrative level, and the court reversed after a 2-day trial at which appellant and her electrician testified that that work had been effectively pre-approved by the agency. It had already been pre-approved. It just wasn't finished. So we believe there is a distinction there, that it is not arbitrary for the court to have granted some and denied others.
How much discretion should we give the trial court in the findings that it's made and the conclusions that it came up with?
How much?
How much discretion?
It is a very broad discretionary statute, so it's an abuse of discretion standard. Is that the question?
No, I just want to know how much do we give a lot of deference to findings or the lack of findings?
Thank you. The findings are entitled to very high deference because the court heard the evidence. And then in terms of the conclusions of law, you review them de novo. But in terms of claims of error, the burden is on the appellant to show reversible error, be it abuse of discretion, that the decision below was arbitrary and capricious, that sort of thing.
Aren't the facts looked at under the standard of whether the evidence supports them? That, there's not discretion on factual, right? It has to be supported by the evidence.
Yes, that's correct. The factual findings, to my understanding, are not challenged here. It's more the sufficiency of those findings in supporting the conclusions. So apologies if I misspoke. Let's see. The environmental court did a commendable job of condensing many years of history in this case, and including the remediation, the cleanup, and the continued back and forth between appellant and the agency long after that was complete. The court properly focused on the material facts, the ones that matter under the statute, and its findings support its conclusions to deny the reimbursement of the remaining costs. This court has stated in Ray Katzenbach and in Ray Burton that as long as the court's findings reasonably support its conclusions, that decision will be upheld. And that's the case here. There's no need to remand for additional findings. Appellant has not shown that the Environmental Division abused its discretion under Section 1941B in denying appellant's remaining claims. The court's decision is consistent with the purposes of the statute, well supported by findings of material fact, and we ask that you affirm. There are no more questions.
All right, thank you very much. How much time does the appellant have, please?
Appellant has 5 minutes and 28 seconds remaining.
Counsel?
Thank you, Your Honors. If I may briefly answer a question Justice Eaton asked, which is, what does incur mean? We think that's a but-for test. And but for the presence of soil contamination, which was discovered under the foundation, none of these costs would have been incurred. And I think that's really the trigger here. Is the statute is very clear. Costs that are incurred. These costs were incurred. The costs that the appellant is seeking recovery for were incurred. We'll also note that we are far below the statutory cap. And I understand that that is not an entitlement, and the appellant has never presented it as an entitlement. But the statutory cap exists for a reason. And that reason is to provide guidance for parties to understand what the scopes of the remedial costs that may be reimbursed are. And it strikes the appellant that the agency's position in some regard is that it could order a property owner to remove contaminated soil under their house and not pay for any of the costs to rebuild the house, not pay for the costs to get an engineer to test the concrete or any of the other myriad of things that are necessary in remedial construction, if it's so desired. And I think that's the fundamental problem, is the court's decision upholds that if it so desires sort of arbitrary decision-making framework. And we think that is the reversible error. Thank you.
Okay, thank you very much. Thank you both. Please call the conclusion of the hearing.
The next hearing for the court is scheduled for 1:45.